Today, we are going to talk about the power of defensive documentation from a claims perspective. And I'm going to share some secrets I've learned from 2 decades of auditing medical records. The insights we identify through our reviews provide a wealth of intelligence into an organization's clinical operations, which helps inform litigation strategy. We do have a unique perspective, having worked on both plaintiff and defense matters. But the conversation today around defensive documentation is neutral. And what I mean by that is maintaining proper and complete records to support the level of care given in any healthcare facility is a non-negotiable. The medical records will be used to help litigation claims, either for you or against you. Without defensive and thorough record keeping, organizations expose themselves to unnecessary risk. We will walk through some very diverse case examples to help demonstrate the adage, if it wasn't charted, it wasn't done, isn't always the best argument. You can find nuggets in the medical records that will bolster your case, no matter what side of the fence you're on, if you know how and where to look. I'm Alicia Davis, founder and CEO of MedLaw Advisory Partners. For nearly 2 decades, we've worked with national and regional healthcare systems, legal firms, insurers, the federal and state government, and senior living operators, helping mitigate risk and manage medical legal claims. Our mission at MedLaw is to provide the necessary resources and expertise to help elevate the delivery of medicine. And one of the ways we do that is sharing our secrets like we're doing today. Because one of our jobs at MedLaw is to evaluate failures in healthcare systems and process. Our hope is that the insights we share are used to guide long-term operational enhancements in quality and patient safety. So thanks for joining us today to listen. I can't stress enough the importance of a thorough clinical assessment of the medical records when evaluating medical legal claims. And in order to get that done, only 3 things stand in our way. Do we have enough time, resources, and expertise? If you can allow the resource people on your team adequate time to review records and identify 1 or 2 nuggets, or sometimes more importantly, the holes, it's going to add value to your case. An early review may very well save your resources by allowing you to properly value the potential claim before it gets too far down the road. For the purposes of our conversation today, defensive record keeping is maintaining proper and complete records to support the level of care provided in a healthcare facility. Most of us have seen that strong record keeping equals a strong defense in medical legal matters. I am going to walk you through the medical records in a few cases so you can see actual examples of documentation pitfalls and the difference that defensive documentation can make in swaying the outcome of a case. Without thorough record keeping, organizations expose themselves to unnecessary risk. Failing to implement proactive record-keeping strategies makes healthcare facilities particularly prone to risk related to COVID-19 liability. Liability protections are still unproven, and immunities that have been put in place are now being revoked in some areas. I know our healthcare workforce is weary, and our frontline workers are being asked to do more than ever before with fewer resources. However, when the staff fails to properly substantiate patient monitoring while under their care, it unnecessarily increases the facility's risk for litigation. The chart examples here were taken from a COVID-19 wrongful death liability assessment that we performed. These examples demonstrate incomplete documentation of oxygen saturation on patients receiving O2 therapy and on residents with orders for every shift O2 saturation assessments for COVID-19 monitoring. In these cases, lack of proper record keeping such as this may result in an inability to support the facility promptly detected, triaged, and isolated potentially infectious patients. Ideally, resources such as audit tools and backup team members should be in place to double check that documentation is completed, to allow for quick follow-up and help keep holes in the medical record to a minimum. These chart examples come from another COVID liability assessment and demonstrate a failure by the staff to completely document the resident's respiratory status and provide details of, quote, other respiratory changes, end quote, noted as a part of the clinical assessment performed. The staff's failure to follow through here undermines their efforts put forth to provide comprehensive care, and it increases the litigation risk. And this can be tough to defend. One of our goals at MedLaw in combating the opioid epidemic is helping ensure safe opioid prescribing practices are in place. We do that by helping prescribers who treat chronic pain patients understand how to comply with the regulations and how to document the monitoring and management of their patients receiving high-risk prescriptions. Medication misuse and diversion is a known issue among patients receiving opioid therapy, and it's imperative that prescribers document the presence or absence of any indicators of medication misuse and take appropriate action. In this audit, findings demonstrated patients with unexpected negative urine drug screens, basically not taking prescribed controlled substances. Although there was evidence in the medical record of action by the physician to intervene, there was no documented evidence of follow-through by the staff. And this applies in not just these particular audits. This issue applies across all medical specialties. And it speaks not only to possible systemic issues that arise from using a combination of electronic medical records, or EMRs, and a paper chart, but also something that we see frequently, which is a breakdown in communication between the members of the care team. And the saving grace here is that we caught this in time for our client to take corrective action internally versus an outside audit flag. The EMR, is it our friend or foe? I'm not caffeinated enough this morning to touch on that topic today, but I will say a huge pitfall that we see in the use of EMR as it relates to claims centers around cookie cutter entries. Some federal and state regulations have specific protocols for how often a patient or a resident is seen and the expected components of the physical exam. It's difficult to prove that care being provided is individualized and person-centered if the assessments in the EMR are cookie cutter. This example here represents a patient receiving chronic opioid therapy and what looks to be a fairly comprehensive patient exam on an outpatient visit. In this case, the physical assessments for July, September, November, and February, however, were exactly the same, down to the punctuation missteps in the record. And this makes it nearly impossible for me to certify that a physical examination of the patient's pain, which is required, was actually performed at each visit, and will be difficult to defend. These notes appear to be carried over from visit to visit and have not been modified or individualized. And I've seen this in acute care records as well, where multiple specialists come in and out daily with very little change in their notes. Copy, paste, copy, paste. And it's hard to defend absolutely no change in a hospitalized patient in 24 hours. And this is another reason why proactive chart QA is really a non-negotiable in these facilities. You can catch things like this. Let's talk for a minute about CMS surveys. CMS has indicated that now more than ever, they are taking necessary steps to ensure long-term care facilities are adequately meeting the needs of their residents through ongoing focused site surveys. And they have also restarted the annual survey process that they had on hold. In this case, our client was a mid-sized regional skilled nursing facility with an immediate jeopardy assessment pending related to alleged substandard wound care provided over a 10-month period to one of their long-term residents. This resident had 13 wounds, and there were significant documentation gaps noted. When we talk about electronic medical records, particularly in long patient stays, in some cases the documentation is there. It's just a matter of actually putting your finger on it, which may sound easier than it is to some of you. In this case, while the survey team was still on site, the MedLaw nurses were able to work with the regional nursing team and the IT department. We combed through the EMR and we put a package together for the survey team's consideration with 1,500 pages of medical records and a memo of findings that supported the care that the facility had provided to the resident. This was a scavenger hunt that paid off because the documentation, for the most part, was there. Although the facility ultimately didn't avoid the immediate jeopardy assessment, the work done to locate the missing medical records significantly reduced the period of noncompliance, which saved the facility hundreds, if not millions of dollars in penalties. The point of this story is what you need for your case may actually be in the medical record somewhere. It just may take a second or a third set of eyes to find it. One of my favorite things to showcase in these talks is the activity of daily living sheets. These are common in assisted living and long-term care centers, and I've seen versions of them in acute care as well. ADL sheets typically document things such as personal hygiene and levels of independence with functioning. They are not federally mandated records, so you might not see them in every facility. And because they are not a mandatory form, they may be destroyed by the time you get around to asking for them in your cases. So you need to keep that in mind. In my experience, ADLs can also be a place for all sorts of useful information that may help or hurt your claim. Understanding the ADL legend is key to interpreting the information. At the bottom of most ADL records, there is a legend that explains what the codes that they use mean, just like the legend on a map. This is a typical ADL for nutrition. In this case, there was an allegation of severe dehydration. There are a lot of codes here that can be pretty difficult to decipher if you don't know or don't take the time to interpret what you're looking at. What's unusual about this ADL, and that you don't see very often in a nutrition ADL, is item number 4 down at the very bottom of the legend. Fluids encouraged. It says mark YE for yes. And as you can see, had we not taken the time to really examine this ADL legend thoroughly, we might have missed this. This just happened to be a defense case, and we were able to support the fact that the staff routinely did encourage fluids. This is another document that we don't often see in ADL records, but we found in this case, which is a fall prevention sheet. The initial allegations in this case were fall with fracture and no bed alarm in place. In the complaint, the plaintiff's attorney detailed that he ran optical character recognition, or OCR, on the records as a search and found no evidence of an alarm used as a fall prevention measure. And two things come to mind for me around this. First, we don't have time today to debate the merits of using alarms to prevent falls. There's a lot of information out there regarding that. But secondly, wouldn't using a human to do a chart review be a better option than running OCR keyword search? It was for the defense in this case. In the legend of this sheet, it provides an option to choose what they call a mobility monitor, also known as a bed alarm, along with about 8 other fall prevention measures. Additionally, we were able to see, when we examined this ADL, a fairly consistent pattern of documented bed and chair alarm use on this resident, which helped in defense of this allegation. This is another example of a fairly typical ADL that we see in most cases, which documents the level of performance with dressing. One of the allegations in this matter was a failure to timely assess for skin breakdown. What's unique about this particular ADL is it also includes an area for skin inspection. And in this case, we noted 2 to 3 skin inspections by the staff per day. Again, had we not closely examined the legend on this, we might have missed this because the initials YE, again, are the only thing indicating that a skin assessment was done. From a defense perspective, this information could provide significant assistance in a wound case when treatment records are missing or inadequate, or other records lack complete physical assessments. And from the plaintiff's point of view, the presence of this type of information in the chart will need to be considered when asserting these types of claims. But we can see how the pattern of consistent documentation in the medical record supports the story of the care being provided when it's done. The next record I want to point out is daily therapy notes, which are just like nurses' notes. They document what happens at each individual therapy encounter versus just the therapy summaries that you see most often. Many times daily PT, OT, and speech therapy notes are either not produced or not reviewed well in these cases, in my experience, and they contain useful information such as early changes in patient condition, sometimes not seen in any other part of the record or not documented in the nurse's notes. This is a snip from a PT daily note. In this case, one of the allegations included fall with subsequent cerebral hematoma. When we examined the therapy notes after we specifically requested them because they were missing, they mentioned a significant change in patient condition in the days leading up to the fall, which was reported to the nursing staff, but was not mentioned in the nursing notes and apparently not followed up on. The finding arguably demonstrated that the patient's fall and subsequent injury were reasonably foreseeable, making the allegation difficult for this facility to defend. One of the other things I want to point out and share today is just a reminder that it can be problematic in a case when a care issue arises with a patient or resident, and the only place the staff documents the details of what happened is outside the patient's medical records. In things such as non-mandatory facility-specific forms, like a 24-hour change of condition report, or in the physician communication book, or only in an incident report, which is QA privileged most of the time and usually not discoverable, which leaves a gaping hole in the medical record around some of these incidents. And since many of these forms are not mandatory, again, they run the risk of destruction over time. The questions that emerged in this case were based on whether a significant medication was omitted inadvertently or withheld due to a clinical consideration or some other reason. There was no information about this, though, in the MAR, the medication administration record, or the nurse's notes. But we know from years of looking at these records that when a medication error occurs, they are typically documented in a 24-hour report or an incident report if the facility is using them. Basically, 24-hour reports are a staff and administration communication tool that is passed on from shift to shift and memorializes out of the ordinary happenings from the day. The report in this case confirmed that the medication omission was a medication error. You can also see some interesting information in this report that documents falls, changes of condition with other residents, and transfers that happened that day. And it's a good example of the fact that you may want to start asking for these reports if you aren't already. But the point I want to make with sharing this slide with you is to encourage facilities to review their incident documentation practices and audit the chart when significant incidents occur, the actual documentation around those incidents. The medical record needs to objectively reflect all the details surrounding the events prior to, during, and after patient events. If the story of what happened is only outlined in a document that's not discoverable by the plaintiffs, it will make defending the care provided more difficult. When we talk about documentation pitfalls, in these cases, many times the issue boils down to a key record that's missing, requiring the defense to try to recreate the story from ancillary documents, or records that we do have that contradict one another, requiring significant time and expense of a deeper forensic analysis to determine what really happened in a case. When the case involves medication administration issues or claims of inappropriate management of pain, pharmacy records and billing can be a place to go to find potentially supportive information or the absence of information in these claims. Pharmacy billing records in particular can play a significant role in mitigating the damage a missing or incomplete MAR may inflict on a case. Here is a matter with allegations of mismanagement of pain and narcotic diversion by the staff. Because the validity of narcotic administration was in question, we needed to perform a full audit of the pharmacy control logs against the resident's MAR. Controlled drug or narcotic logs are required documentation per the pharmacy board, and they typically include the name of the drug, the date, time, and dose, and who administered the medication. Controlled drug or narcotic logs should be included as a part of the medical record requested if the patient is on a controlled substance, but sometimes they have to be specifically requested. When the narcotic logs were compared to the medication administration records in this case, our audit determined that there was significant and inconsistent documentation on both the MAR and the controlled drug logs. 101 doses of Ativan were given. 37 of those doses that were on the controlled drug log were not documented on the MAR. There were 20 doses on the MAR that were not in the controlled drug logs. And this involved multiple employees. So the question we were left with was, is this just a systemic failure of the facility to follow their own policy for administration of narcotics and required documentation, or diversion, or possibly both? This is another example of missing and contradictory record keeping in a case with an allegation of falls and mismanagement of pain post-fall. When we examined the medical records related to this resident's pain, we noted documentation for administration of scheduled narcotics stopped abruptly in July without evidence of physician discontinuation or modification of the drug. And there was no evidence of narcotic administration at all on the August MAR, the month following this one. Documentation in the nurse's notes, however, indicated that the scheduled pain medication likely continued during the period in question. An additional records request yielded a controlled drug log for only part of the month in question, which did document the medication was logged out at least 3 times or continued to be logged out at least 3 times daily, documented as given, and as you can see here, inconsistently documented on an MAR, which was still missing. Does any of this sound familiar? It's, the rabbit hole that we go down sometimes to find what we need to find to substantiate what happened. Now we can try and help bolster the defense in this case and fill in some of the holes by going further down that rabbit hole and requesting the pharmacy detail records, which may or may not show the amount of medication the resident was billed during this time, depending upon the billing arrangements. But without the MARs or the controlled drug logs, it may be a challenge to prove that the resident actually received the medication. But all of this is going to take more time, more effort, and additional expense to put together. So you can see the impact of one incomplete MAR, one missing MAR, one incomplete controlled drug log for the month, one missing controlled drug log can have on a claim. Taking the extra second to consistently ensure that the boxes are checked and notes are made will make it easier to argue that the care was actually provided. This is defensive documentation. I've just shared with you 12 stories with about 20 medical records about the power of defensive documentation and what can happen when there are holes in the medical record. My hope is that healthcare practitioners here will think through the areas where you can take a little extra time to ensure medical record documentation is thorough and consistent to support the care being delivered. I also hope that those of you involved in medical legal claims see the impact that an investment in a comprehensive clinical review of the medical records can make in these cases. Thank you again for joining us today for this chat. Please reach out if we can be of assistance in any way.